We knew this was coming, right? We knew Donald Trump was going to submit a motion and ask the judge to recuse herself from his case. We knew it was coming, right? Well, he and his team of lawyers filed that motion on yesterday. Let's talk about it. Hey everybody, welcome back to the channel. I am Tabitha, and yes, as expected, Donald Trump and his team of lawyers submitted a motion for Judge Tanya Chutkan to remove herself from his case. I've got the motion right here. The entire motion is 25 pages long, but that's with the motion and the exhibits, the evidence to back up what they are claiming, right? We don't need the evidence of what they're claiming because it's also included in the motion itself. I'm going to read it in its entirety. Yeah, and you know I have some thoughts about what I'm reading along the way. So this was submitted on yesterday, and it's titled Defendant Donald J. Trump's Motion for Recusal of District Judge Pursuant to 28 U.S.C. 455A. President Donald Trump, through undersigned counsel, respectfully moves to recuse and disqualify the Honorable Tanya S. Chutkan pursuant to 28 U.S.C. 455A. Fairness and impartiality are the central tenets of our criminal justice system. Both the defendant and the public are entitled to a full hearing on all relevant issues by a court that has not prejudged the guilt of the defendant and whose neutrality cannot be reasonably questioned. The only people that are questioning Judge Chutkan and her being biased are MAGA supporters. Not even Republicans. MAGA supporters, or like Lauren Boebert puts it, ultra MAGA supporter. Judge Chutkan has, in connection with other cases, suggested that President Trump should be prosecuted and imprisoned. Such statements made before this case began without due process are inherently disqualifying. I'm not an attorney. I don't have a legal background. I didn't study law at all, unless you're talking business law as it relates to business management. But they're talking about previous statements that she's made, not necessarily statements made while she has been the judge presiding over Donald Trump's case. I wonder if that makes a difference. Let's continue. Such statements made before this case began and without due process are inherently disqualifying. Although Judge Chutkan may genuinely intend to give President Trump a fair trial and may believe that she can do so, her public statements unavoidably taint these proceedings, regardless of outcome. The public will reasonably and understandably question whether Judge Chutkan arrived at all of her decisions in this matter impartially or in fulfillment of her prior negative statements regarding President Trump. Under these circumstances, the law and the overwhelming public interest in the integrity of this historic proceeding require recusal. The disqualifying statements. In October 2022, before the special counsel's appointment or the filing of this case, so they're saying that these statements were made prior to the filing of this case. Judge Chutkan stated, "This was nothing less than an attempt to violently overthrow the government, the legally, lawfully, peacefully elected government, by individuals who were mad that their guy lost. I see the videotapes. I see the footage of the flags and the signs that people were carrying and the hats they were wearing and the garb. And the people who mobbed that Capitol were there in fealty, in loyalty to one man, not to the Constitution, or which most of the people who come before me seem woefully ignorant, not to the ideals of this country and not to the principles of democracy. It's a blind loyalty, and they put in italics, to one person who, by the way, remains free to this day. Now, see, I don't see what the issue is with this statement. I don't see her displaying any bias. I see her calling out the facts that were presented in the case. One fact is that Donald Trump is still free. That is a fact. He's still walking around, not behind bars. She said this to a January 6th rioter who was in her courtroom and being sentenced. So this was a part of her sentencing statement. Moving on. United States versus Christine Priola. They are citing a case. The public meaning of this statement is inescapable. President Trump is free, but should not be. So they're saying that she's implying with making that statement. The statement again is to one person who, by the way, remains free to this day. They're saying the implication of that statement is saying that Donald Trump should not be free. But how do you not know? She's not just saying that you did all of this and Donald Trump is free and now you're standing before me and I have to sentence you to prison because of your loyalty to this man. Okay, I'm not an attorney. As an apparent they're saying as an apparent prejudgment of guilt, these comments are disqualifying standing alone. However, this was not the first time Judge Chutkan expressed an opinion. In December 2021, Judge Chutkan similarly suggested that in her view, President Trump was responsible for the events of January 6, 2021 and should be prosecuted. Okay, here's what she said, that they're saying that Judge Chutkan basically said that Donald Trump was responsible for the events of January 6th. He went to the Capitol because despite election results, which were clear-cut, despite the fact that multiple court challenges all over the country had rejected every single one of the challenges to the election, Mr. Palmer didn't like the result. He didn't like the result, and he didn't want the transition of power to take place because his guy lost. And he didn't want the transition of power to take place because his guy lost. And it is true, Mr. Palmer. You have made a very good point, one that has been made before, that the people who exhorted you and encouraged you and rallied you to go and take action and to fight have not been charged. That is not this court's position. I don't charge anybody. I don't negotiate plea offers. I don't make charging decisions. I sentence people who have pleaded guilty or have been convicted. The issue of who has or who has not been charged is not before me. I don't have any influence on that. I have my opinions, but they are not relevant. So she's basically admitting that she has her opinions, but they are not relevant to the case or to whatever her sentencing, her punishment that she hands down. So they're saying Judge Chutkan similarly suggested that in her view, President Trump was responsible for the events of January 6, 2021. And they present this statement Houseway. Houseway. She's just telling them how it is. She doesn't charge people. She doesn't negotiate plea offers. She doesn't make charging decisions. All she does is sentence. It goes on. So you have a point that the people who may be the people who planned this and funded it and encouraged it haven't been charged. But that's not a reason for you to get a lower sentence. She ain't worried about those people. Those people are off doing whatever. They're not standing before me in front of this court. You are. And I'm going based on the specifics of this case and the evidence presented in this court. I think, yeah, they pushing it with that. United States versus Palmer. They're citing a case. In making these statements, Judge Chutkan agreed with portions of the defendant Palmer's sentencing memorandum, which similarly and wrongly placed blame on President Trump. No, she didn't. I don't think she did. But of course, you'll let me know how you think down in the comments. She didn't. She agreed with what he said. He said that, you know, those who encouraged him to do what he did, to go to the Capitol, they're not even charged. She agreed with him because that's a fact. No way did she insinuate that Donald Trump was responsible. She, in fact, told him, this person that she's sentencing, that, but none of these people are of my concern because they're not standing before me. You are. None of that is relevant. She went on to say she has her opinions, but that's still not relevant to this case. I'm no attorney, though. In making these statements, Judge Chutkan agreed with portion of the defendants Palmer's sentencing memorandum, which was a fact. They weren't charged. These people weren't charged, which similarly and wrongly placed blame on President Trump and complained that he had not been charged. I can't wait to read y'all comments. Quote, these voices, including the voice of the then president himself, has convinced persons such as Mr. Palmer that the election was fraudulent and that they must take action to stop the transition of the presidency. So they're saying that statements made by Judge Chutkan and President Biden, those were the reasons that stirred him to go to the Capitol to attack the Capitol. Not Donald Trump telling them, if you don't fight, you're not going to have a country anymore. You have to fight like hell. Not Donald Trump saying that. Not Donald Trump saying, we're going to go down to the Capitol building. I'm going to go down with you. And he didn't go. Not that. Not the weeks before, Donald Trump out there every single day on social media screaming that the election was stolen, that the election was fraudulent. Okay, it's Judge Chutkan and what she didn't say, in my opinion. All right. While many of the people who participated in the Capitol riot will be going to prison, the architects of that horrific event will likely never be charged with any criminal offense. I beg to differ. The architects have been charged, specifically here in Georgia. 19 of them, including Donald Trump. They've been charged. Although Judge Chutkan correctly noted that she does not have any influence on charging decisions, her above comments stating, quote, you have made a very good point that the people who exhorted you and encouraged you and rallied you to go and take action and to fight have not been charged. And you have a point that the people who may be the people who planned this and funded it and encouraged it haven't been charged. But that's not a reason for you to get a lower sentence. They're saying that statement reflects her apparent opinion that President Trump's conduct, one, occurred, and two, supports charges Otherwise, she would not have characterized the point as very good. Similarly, Judge Chutkan's statement that I have my opinions suggests that in her view, formed almost 2 years before the initiation of this matter, President Trump should be charged. I don't think so. Because she followed up with, but my opinions aren't relevant. Public statements of this sort create a perception of prejudgment incompatible with our justice system in a case this widely watched of such monumental significance. The public must have the utmost confidence that the court will administer justice neutrally and dispassionately. Judge Chutkan pre-case statements undermine that confidence and therefore require disqualification. Next section, applicable law. Quote, unbiased, impartial adjudicators are the cornerstone of any system of justice worthy of the label. In Re al-Nashiri, I guess this is a case that they are citing. Thus, any justice, judge, or magistrate judge of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. Code of Judicial Conduct, Canon 2A, a judge should respect and comply with the law and should act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. Under settled law, what matters is not the reality of bias or prejudice, but its appearance. They cite a whole bunch of cases. Therefore, all that must be demonstrated to compel recusal is a showing of an appearance of bias sufficient to permit the average citizen reasonably to question a judge's impartiality. It cites the case again. This inquiry is an objective one, made from the perspective of a reasonable observer who is informed of all the surrounding facts and circumstances. In other words, it is of no consequence that the judge is not actually biased because concerns not only fairness to individual litigants, but equally important, it concerns the public's confidence in the judiciary, which may be irreparably harmed if a case is allowed to proceed before a judge who appears to be tainted. So when they say the justice system will be viewed and caused, it would be irreparably harmed because the judge is being viewed as biased or tainted, right? Having pre-thoughts on the defendant, right? They're talking about the MAGA people. And we have to talk about how unreasonable the MAGA people are. There's nothing that you will be able to do to please the MAGA people. The MAGA people have more than shown us that they are unreasonable. I mean, hell, all of this has come about because the MAGA people are unreasonable. They thought the proper course of action was to attack the United States, the Capitol building. Judge Chutkan recuses herself. Another judge comes in, and that judge doesn't do what they want them to do. That judge is also going to be tainted. And around and around and around we go. Moving on. This portion of the disqualification statute is to exact the appearance of impartiality. It focuses on what is revealed to the parties and the public, as opposed to the existence, in fact, of any bias or prejudice. As the Fifth court stated, this overriding concern with appearances, which also pervades the Code of Judicial Conduct and the ABA Code of Professional Responsibility, stems from the recognized need for an unimpeachable judicial system in which the public has unwavering confidence. As this court has noted, quote, the protection of the integrity and dignity of the judicial process from any hint or appearance of bias is the palladium of our justice system, end quote. Any questions of a judge's impartiality threatens the purity of the judicial process and its institutions. Quote, such a stringent rule, to be sure, may sometimes bar trial by judges who have no actual bias and who would do their very best to weigh the scales of justice equally between contending parties. However, to perform its high function in the best way, the Supreme Court has emphasized justice must satisfy the appearance of justice. Therefore, to preserve both the reality and appearance of impartiality, a judge should recuse herself when her impartiality might be reasonably questioned. See United States versus Microsoft. The very purpose is to promote confidence in the judiciary by avoiding even the appearance of impropriety whenever possible. Appearance may be all there is, but that is enough to invoke the canons of judicial conduct. Counsels a low threshold requiring disqualification if any reasonable citizen could question a judge's impartiality, even if some do not. Accordingly, when a judge harbors any doubts concerning whether his disqualification is required, she should resolve the doubt in favor of disqualification. Argument. This is little doubt that reasonable members of the public might, in viewing Judge Chutkan's statements, believe she has prejudged both the facts pertinent to this case and President Trump's alleged culpability. Judge Chutkan's statement that, quote, it's a blind loyalty to one person who, by the way, remains free to this day, end quote, straightforwardly and of course incorrectly in the defense's view, suggests that President Trump has culpability for the events of that day and should not be free. This would be a natural interpretation of her comments in any context, but is particularly poignant here, where Judge Chutkan directed her statements to a defendant she was about to sentence to an extended term of incarceration. But wait a minute. Judge Chutkan didn't find this defendant guilty. A jury found this defendant guilty. Right? And she's sentencing based on that guilty verdict. How is she I don't get it. I don't get it. Indeed, her comments suggest that reached a conclusion before this case that President Trump is more deserving of a term of imprisonment than the defendant she was sentencing. To me, this sounds like their motion is them putting words into Judge Chutkan's mouth. That's what this motion is to me. Likewise, most reasonable observers would understand Judge Chutkan's statements that it is true, Mr. Palmer, you have made a very good point, one that has been made before, that the people who exhorted you and encouraged you and rallied you to go and take action and to fight have not been charged. I don't have any influence on that. I have my opinions, but they are not relevant. That's what she said. She has her opinions, but her opinion is not relevant. as both a pre-case determination of disputed facts that President Trump exhorted, encouraged, or rallied others for unlawful action. Okay, but he did. We all watched him do it. We saw all of his tweets. We heard him over on Fox News, on Newsmax. He did just that. He did that. And a suggestion that President Trump may and should be prosecuted based on those facts. No, she didn't suggest that at all. She said this man had a blind loyalty. And he may be right in saying that, those who encouraged him and rallied him to go to the Capitol aren't charged. But she went on to say, but I have opinions about it, but my opinions are not relevant. Am I missing something here, y'all? Moving on. Courts have found an impermissible level of bias when a judge's remarks or actions reveal she has prejudged the guilt of a defendant. But Donald Trump wasn't the defendant. Judge Chutkan made her comments from the bench during court proceedings, which only amplifies the concern of prejudgment. President Trump was not a party to these cases and had no ability or opportunity to object, perhaps even to persuade, and the judge would have made a record for review on appeal. But in all honesty, Donald Trump's name wasn't even mentioned. I guess it's the blind loyalty part to one man that implies it's Donald Trump. Moreover, because the statements were made on the record in support of the court sentences of incarceration, the public must reasonably understand them to be the product of considerable thought on the part of Judge Chutkan, reflective of her core views that are unlikely to change. And as President Trump's supposed culpability was not an issue for Judge Chutkan to decide in the Palmer or Priola sentencing, the public can reasonably understand that her views on President Trump derive from extrajudicial sources. Every judge must uphold her oath of office. This is so faithfully and impartially discharge and perform all duties incumbent upon me under the Constitution and law of the United States. So help me God. The foundation of that oath is a judicial branch designed by our founders to be entirely impartial and avoiding even the perception of prejudgment. Our system guarantees that the government prove a defendant guilty in front of a jury of his peers as part of a trial without any suggestion of partiality on the part of the presiding judge. Only when all three prongs are present and beyond dispute does our judicial function as intended. Both by its procedure and its content, his trial is a test of the very foundations upon which our government is built. There is an overwhelming public interest in ensuring the perceived fairness of these proceedings by the ultra-MAGA crowd. In a highly charged political season, which is as a result of your defendant, naturally all Americans, and in fact the entire world, are observing these proceedings closely. Only if this trial is administered by a judge who appears entirely impartial could the public ever accept the outcome as justice. Section 455A commands a judge to recuse herself if her impartiality might reasonably be questioned. The standard is not particularly high, especially in a case as here, where the Department of Justice answers to a president who is prosecuting his main leading opponent in an election that will take just over a year. The Justice Department is not prosecuting Donald Trump. A grand jury got together, saw the evidence, and said, yes, based on this evidence, Donald Trump needs to face trial. It wasn't the President of the United States. It was a grand jury that indicted Donald Trump. Now, I think attorneys who do this, who are doing this, using the justice system to prolong this case so that Donald Trump doesn't have to answer to justice, and uses these lies that they know are lies, I think there should be consequences for this nonsense. Where the Department of Justice answers to a president who is prosecuting his main leading opponent, they know that's a lie. They know the president is not prosecuting Donald Trump. They know this. Now is not the time for the American people to second guess a judge's impartiality. Rather, the court should ensure the public remains unwaveringly confident in its decision and its commitment to the fair and impartial administration of justice. Therefore, President Trump requests Judge Chutkan recuse herself from further proceedings. Conclusion. For the foregoing reasons, Judge Chutkan should recuse herself from this case and direct the clerk to randomly assign this matter to another district judge. I bet you they would love Judge Eileen Cannon to be on this case as well. Not going to happen. Additionally, given the overriding public interest in ensuring the appearance of fairness in this proceeding, President Trump requests the court consider this motion on an expedited basis and pending resolution without withhold ruling on any other pending motion. Let me know your thoughts on the motion, but Judge Chutkan has responded to Donald Trump's request for her to recuse herself. Her response was filed on yesterday, and it reads, Minute order as to Donald J. Trump. Upon consideration of defendant's 50 motion for recusal, it is hereby ordered that the government shall file any opposition no later than September 14, 2023, and the defense shall file any reply within 3 calendar days from the filing date of the government's opposition. So, Jack Smith we got to do all of this within 3 days. No, Jack Smith has time to respond, right? And then from the time that Jack Smith responds, they have 3 days for the defense to then respond to that. All other deadlines set by the court remain in effect. And that was one of his requests. President Trump requests the court consider this motion on an expedited basis and pending resolution without rulings on any other pending motion. So they wanted to put everything, I'm reading that as they wanted to put everything else on hold while they go through this process, which what prolongs the case. But moving on. Judge Chutkan said no. All other deadlines set by the court remain in effect. Defense counsel is reminded of the requirement to confer with opposing counsel before filing any motion and to indicate whether the motion is opposed. See 9/5/2023 second minute order. Future motions that fail to comply with that requirement may be denied without prejudice. Signed, Judge Tanya Chutkan. Now, the lawyers, I only watch MSNBC. The lawyers are, having their commentary and they're talking about this. And a lot of them feel like, this motion is not going to go anywhere. She's not going anywhere. And it's all based on how things have processed thus far, right? You were okay. You didn't request for Judge Chutkan to be recused from the beginning of this process. But now that she has done something, which was scheduled the trial to start the day before Super Tuesday, now that she has done that, you're upset and you want a new judge, and it doesn't work that way. But I went to see what I wanted to know what George Conway had to say, right? Here's what he said. A careful reading of this excerpt from Trump's recusal brief shows it's not Judge Chutkan who has expressed the view that inmate number P01135809 was responsible for the events on January 6th. Okay, but rather Trump's lawyers via their assumption that their client planned the attack. Oh my God. Now that is a way of looking at it. No. Right? Because Trump hasn't even been on trial. So for them to believe that Judge Chutkan believes that Donald Trump is responsible, then they are assuming that their client planned the attack. He put oops. Oh my gosh. This is why I follow him. You know, we don't think the same politically. And I told y'all, I don't have a problem with Republicans. It's the MAGA Republicans, them QAnon Republicans, the evangelical Republicans. If we can have respectful dialogue based on facts and reality, and you want to do what's best for the country, I can have a conversation with you. I cannot have a conversation with MAGA people because they're not grounded in reality. Their thought process, their opinions are not based on facts. They're based on conspiracy theories, lies, hatred, and racism. Anywho, there was a great commentary on Lawrence Odell's show last night, and I'm going to leave you with that, between the attorneys and their thoughts on the motion and their opinions on if, the motion is going to go anywhere or if Judge Chutkan is going to recuse herself. That's all I got. Y'all check out the conversation that's happening with Lawrence O'Donnell. Is coming up next. I'll see y'all in the next one.
Of Judge Chutkan, this is a decision for the judge to make herself. This motion seems to be a very well-argued motion, isolating these two comments that she made in sentencing of January 6th defendants.
Well, I'm going to disagree with you about well argued. If you are going to make this motion, first, it needs to be made timely. You don't get to sit on your rights for 6 weeks, see what the judge does on your effort to delay a trial date. Then when you don't like that ruling, say, you know what, now I want a different judge. And that's why the law requires these kinds of recusal motions to be made at the very first instance, instead of playing games, which is what happened here. Second, judges are allowed to, at sentencing, express views about co-defendants. That's all that happened here. There is nothing that you have read that is not 100% true and accurate. And then finally, it is really hard to be talking about recusal when we're sitting with at least 2 Supreme Court justices in situations that actually call for recusal who are not doing anything whatsoever. That's Justices Thomas and Alito. And the idea that Judge Chutkan should recuse herself based on valid comments made about co-defendants at sentencing, where the federal sentencing guidelines call on judges to make these comments at sentencing, really, to me, is beyond the pale and shows, to my mind, that the lawyers are not exercising any control on their client.
But Andrew, Donald Trump wasn't a co-defendant at the time the judge made these comments.
Yeah, but that doesn't mean that you can't look at the facts of what happened. And he is, for all intents and purposes, he is a co-defendant now. And so when you have a case before you and you are at sentencing, you have to describe for the particular defendant why you are sentencing the person to a particular time, why you are accepting arguments, and why you are rejecting arguments. That can involve other people, people who are charged and people who are not charged. So there's nothing about what she said that's improper. It's actually important for her to say why she is accepting things. Nothing about the two statements that you read in any way, to my mind, mean that she cannot be fair or even an appearance of impropriety or not being able to be impartial.
Neil, that's the appearance point is kind of the most important in a way, and that's the one that the lawyers lean on the heaviest. They grant that it is entirely possible that the judge believes that she is impartial and will absolutely try to conduct the trial in an impartial way. But they say that there could be a very large perception out there that she is not fair, that she is biased because of these statements.
Yeah, Lawrence, I mean, it's not surprising in a way that Donald Trump is making these kinds of arguments. I mean, Judge Chutkan is Donald Trump's least favorite kind of judge, an honest one. And when we talk about the appearance of impartiality, I think there are two problems with it, and both Andrew has pointed to. One is if you have an impropriety, you don't get to sit on your hands for 42 days, which is when Judge Chutkan was assigned, participate in a bunch of proceedings, and then decide you don't like them, and then try and seek a new judge. I mean, these statements that Trump is pointing to were made in 2021 and 2022. They're not like things that she just said. And so I think that removes the appearance issue, because if anything, the appearance is of an improper motion occurring after the fact. The other thing that Andrew was getting at is that these statements are made in court all the time. Indeed, 10 different judges in Washington, D.C., 10 different federal judges, Lawrence, have made similar statements about January 6th defendants and Donald Trump. Judge Bates, who is one of the most respected judges in D.C., former Whitewater prosecutor under Ken Starr, said something similar to what Judge Chutkan said. Judge Kolar-Catelli, another one of the most respected judges, she said the following, quote, "At the Stop the Steal rally, President Trump exhorted his supporters to, in fact, stop the steal by marching to the Capitol." So you've got a bunch of different statements by judges already. And I think this is something that the Justice Department and Jack Smith, the special counsel, understand really well, because you can remember all the things that Judge Cannon did last year in the stolen documents Mar-a-Lago thing, actual rulings made about Donald Trump that are wackadoodle and slapped down by the Court of Appeals. But you didn't see the Justice Department going and crying and saying, oh, we need a different judge, appearance of impartiality, things like that. They understand the threshold, the standard is very difficult. They didn't file such a thing. And I think, here it's unfortunate that the lawyers did file such a thing, but I don't think it's going anywhere.
Andrew, so the judge makes this decision herself. If she decides not to recuse, will the Trump lawyers and can the Trump lawyers appeal that decision?
They can try to. It seems unimaginable to me that a panel in the D.C. Circuit, even with the most sort of pro-Trump panel, is going to do this. You have to remember, Judge Chutkan is so well respected, and the precedent it would set in these kinds of cases would just be untenable. I just think when you have a recusal motion, it's very hard to win. I don't think that Donald Trump's lawyers actually think they're going to win. When I read this motion, I thought it was for the MAGA base, and that's where they want the appearance to be that she's unfair. I think that is the audience. I don't think it's for Judge Chutkan or the D.C. Circuit. And that's why I said I think that this shows that the lawyers are really not in control. If they ever were, this is the kind of filing that you just don't make, and you don't make it at this time.